Swayam Prabha. Digital India. Educated India.
Amendments during prosecution. Chapter 10 of the Patents Act deals with amendments of application and specification. 57 talks about amendment of an application and specification before the controller generally. What are the kinds of amendments and what is the procedure to be followed? 57 states in subsection 6, the provision of this section shall be without prejudice to the right of an applicant for a patent to amend his specification or any other document related thereto to comply with the directions of a controller issued before the grant of a patent. So, if the controller issues a direction for amendment before the grant of a patent, which is what we call amendment during prosecution, then it shall be without prejudice to the provisions of 57. So, you will find under section 15 the controller may ask the applicant to amend, the applicant can amend. So, that need not follow the procedure, it is without prejudice to the procedure mentioned in section 57, and the controller may ask an amendment in cases of potential infringement. The controller may ask a reference to be made in case of anticipation. In all these cases, the amendments that occur are amendments that are conducted or carried out during prosecution, and that comes under section 57(6). Those amendments that are carried before the grant of a patent shall be without prejudice to the right of an applicant. Amendment of application and specifications. Section 57, amendment of application and specification before controller. Under section 57, when an application is made under this section in a prescribed manner by an applicant for a patent or by a patentee, which means section 57 is applicable for amendments before the grant, applicant, and amendments after the grant by the patentee, allow the application for the patent or complete specification or any document. Now, these are the three categories of amendments. You can amend the application for a patent, that is form 1 and accompanying documents. You can amend a complete specification, that is form 2, and you can amend any other document like drawings or any other document that you will file along with your patent applications to be amended subject to such conditions, if any, as the controller thinks fit. Now, the proviso says that the controller shall not pass any order allowing or refusing amendment while a suit is for infringement is pending before a high court. So, that is an exception. Now, every application for leave to amend an application for a patent or a complete specification or any document under this section shall state the nature of the proposed amendment. So, leave to amend means the permission to amend. So, the procedure requires you to take permission before an amendment, and there you have to mention the nature of the proposed amendment. What is the nature of the proposed amendment, and shall give full particulars for the reasons for which the application is made. So, the nature of the proposed amendment and the reasons for the amendment have to be mentioned. 3. Any application for leave to amend, which is the permission to amend an application for a patent or a complete specification or a document made after the grant of a patent, and the nature of the proposed amendment may be published. So, an amendment after the grant needs to be published. Now, this is a critical distinction between amendments made before the grant and after the grant. Amendments before the grant are much easier. It can be done before the patent office, and those amendments need not be published, but all amendments after the grant require publication. and once a proposed amendment is published, it could also trigger opposition proceedings. You find that in the next subsection. When an application is published under subsection 3, any person interested may give notice to the controller of opposition. So, amendments can also be opposed, but the amendments that can be opposed are only amendments after the grant. 5. An amendment under this section of a complete specification may be or include an amendment to the priority date of a claim. So, not only can you amend form 1 and form 2, the accompanying details of a patent, the substantive details of an invention, you could also carry an amendment to the priority date of a claim. And we had already seen subsection 6, which says that this provision is without prejudice to the amendments that are carried before the controller in pursuant to the directions issued by the controller before the grant of a patent. Now, 58 deals with amendment of specification before the appellate board or the high court. Now, 58 tells us that if the amendment has to be done before the appellate board or the high court, it already tells us that there is a grant of a patent. So before the appellate board or before the controller, where there are revocation proceedings, in any proceeding before the appellate board or high court for the revocation of a patent. Now, the appellate board proceedings which have come upon appeal. Now, if an application is rejected under section 15, that could be taken up before the appellate board, and in the proceeding there could be an amendment to that application. But in cases of revocation, the appellate board also has revocation powers. In case of revocation of a patent, the appellate board and the high court will be looking at a granted patent. As the case may be, may, subject to provisions of subsection of section 59, allow the patentee to amend his complete specification in such manner and subject to such terms as to costs, advertisement or otherwise, as appellate board or the high court may think fit. And if any proceedings for revocation, the appellate court may decide the patent is invalid, it may allow the specification to be amended under this section instead of revoking the patent. This provision tells us that wherever there is an amendment, it has to be advertised, and in case court or the appellate board comes to a conclusion that the patent is invalid, instead of revoking the patent, if the patentee offers an amendment and if the amendment can be carried out and if the patent can be allowed, then the appellate board or the high court, instead of revoking it, would allow the amendment. Now, this option is there in section 15 as well as in section 25(4). The controller has the power, instead of revoking or refusing an application or revoking a patent, he has the power to amend and maintain the patent. So, similar power is given to the appellate board and the high court. Now, the appellate board or the high court shall give notice of the application to the controller, and the copies of all orders shall be passed on, transmitted to the controller, and the controller shall correct the register. So, if there is some amendment, the register needs to be corrected. 59 talks about the scope of amendment, what can be amended and what cannot be amended. 59. Supplementary provisions as to amendment of application or specification. Amendments can only be made by way of a disclaimer, correction or an explanation. So, the kind of permitted amendments are disclaimer, by which you give up something, correction, by which you carry out a error which is corrected, or explanation, something is not clear, you explain it. It also says that no amendment shall be allowed except for the purpose of incorporation of an actual fact. So, what you include in an amendment is an actual fact. Amendment is only for errors of fact or omissions of fact. And further, 59 says that no amendment shall be allowed, the effect of which would be that specification as amended would claim or describe matter not in substance disclosed or shown in the specification before the amendment, and that any claim of the specification as amended would not fall wholly within the scope of the claim of the specification before the amendment. This incorporates the principle of fair basis. If you amend your specification, by amending you should not be claiming or describing matter that was not disclosed in the specification before the amendment. And if you make some change to the claim will still have to be fairly based on what you have disclosed before the amendment. So, you cannot, in other words, expand the scope of your invention, which brings a principle in patent amendments, is that the amendments can only be done to narrow down the scope of an invention. You can't expand the scope of an invention. Now, what do you need to do if you want to expand the scope of invention? You simply file a patent of addition, or if it warrants, you file another patent application. So, if the object is to expand the scope, you want to include another modification or you want to include another improvement to an existing invention, then you do not carry an amendment for that. What you do is you file a patent of addition. So, patent of addition in that way is connected to amendment itself. Now, subsection 2 says that where after the grant of a patent any amendment is done is allowed by the controller or the appellate board or the high court, the amendment shall deem to form a part of the specification along with other documents. The fact that the other documents relate thereto at amendment shall be published, they shall be publication. The right of the applicant or patentee to make an amendment shall not be called to question except on ground of fraud. Now, in construing the specification as amended, reference shall be made to the specification as originally accepted. So, these are the principles that normally follow an amendment. An amendment cannot be questioned except on ground of fraud. So, fraud vitiates an amendment that is carried to the patent. Section 64(1)(o) states that as one of the grounds of revocation of a patent, that the leave to amend the complete specification under section 57 or section 59 was obtained by fraud. So, if you obtain the leave to amend by fraud, that could be a ground for challenge. The relevant rules for amendment of application, specification or any other document is contained in Rule 81. Rule 81, amendment of application, specification or any other document relating thereto. The amendment of an application under section 57 has to be done in form 13. Form 13 is the form that is used for amending specifications or document or the application for patent itself. 81(2) states that if the application for the amendment has not been granted, the controller shall determine whether and subject to conditions, if any, the amendment should be allowed. 3(a) says if the amendment under Rule 1 is made after the grant, then the nature of the proposed amendment is substantive. So, two things, the amendment is after the grant and the proposed amendment is substantive. So, I kept using the word substantive as opposed to clerical. Now, we understand that if it is after the grant and the amendment is substantive, the applications shall be published. So, publication comes in not in every case where the amendment happens after the grant. There is an additional requirement that though the amendment happens after the grant, the nature of the post amendment has to be substantive. So, if it is not substantive, it need not be published. B, any person can give notice of opposition in form 14 within 3 months from the date of publication of the application. So, form 14 is used for notice of opposition of amendment. Now, the form 14 is a common form for notice of opposition of amendment, of restoration, surrender of patent, grant of compulsory license and correction of clerical errors. So, all these provisions has form 14, but form 7 is used for notice of opposition in the case of a post grant opposition. So, form 4, form 7 and form 14 are used for different kinds of oppositions. The procedure specified in rules 57 to 63 relating to written statement, reply statement, leaving evidence, hearing and cost, so far as may be applied for a hearing of opposition under section 57. Now, we saw that rules 57 to 63 are provisions pertaining to how post grant opposition has to be conducted. The same procedure will follow for opposition of amendments too. 82 preparation of amendment specification etc. Where the controller allows the application for a patent or any other document, the applicant shall, if the controller so requires and within the time period specified by him, leave at the appropriate office an amended application or specification as the case may be in accordance with the rules. So, a copy of the amended document, be it application, specification or any other document, has to be left at the appropriate office. Now, 83 publication of amendments allowed. The amendment allowed after the patent has been granted shall be published. We saw this in section 57.